Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue with your closing argument.
Defendant had made her way to Pasadena along with her will to kill Mr. Alexander in the evening of June 3rd of 2008. And she stopped at the Starbucks. And after stopping at the Starbucks, or as part of this stop, she decided to fill up. And we know that she had the 3 gallons of gas, or the 3 gas cans at that point, based on the receipts that are before you. And the reason that she had those gas cans filled is so that now she was prepared to make it all the way through Arizona without having to stop for gasoline. And she, on her direct testimony and also part of cross-examination, indicated that, well, the car, for whatever reason, had a bad engine, for lack of a better term. It kept using gas so much, trying to manipulate you into thinking that she stopped at a number of places and used all the gas in the gas cans. But there are no records or any other corroborative evidence that indicates that she stopped anywhere here in the state of Arizona for gasoline. So her plan, if you will, was working well at that point. She wanted to kill him. There was no way that anybody would be able to say that she was even in the state of Arizona, because the defense would have been, well, I would have had to have stopped for gas. And there was no indication anywhere, and there is no indication anywhere that she stopped for gas in the state of Arizona. Another thing that she did as she came into the state of Arizona is she turned off her telephone. And this telephone, the cell phone that she had, was turned off so that it could not be traced by law enforcement. So now not only do you have her in a vessel, an automobile that will not be traced to the state of Arizona, you also have her with a telephone that is turned off. She gave several reasons to different people as to why the telephone was turned off. One of them that she gave to Ryan Burns was that somehow it had lost its charge, and that she had lost the charger, and somehow she'd been able to buy it at some store. That was her story, and then she was able to charge the telephone so that she then was able to call him near Hoover Dam. Another story that she gave was that, well, when she stopped on the side of the road and she was cleaning up from killing Mr. Alexander, she actually was able to go underneath the seat and find the charger. Either way, the net effect of that was that as she came into Arizona, there was no electronic trail of her being here, and there was no physical trail of her coming through. And this was done for the purpose. She knew that she was coming to kill him. There is no other reason why you would turn off your telephone as you're coming through here, especially this woman who clearly loved to use her telephone, but for this particular trip, for this time when she's approaching Mesa, telephone is off. And it doesn't come on until sometime later near Hoover Dam, again indicating she was never in the Mesa area. And without the electronic trail, it would have been difficult for the police to find that out. So now you have her in a position where she can come to Arizona and no one's going to know. She's in a car that's white, not red, so the police are not going to stop her. And she shows up with a gun and a knife. And she shows up to see Mr. Alexander. And if you remember that one of the things that she told the police officer, she always, whenever it was not to her benefit, would say, well, no, I was lying then. As if somehow that's a fallback position. As if somehow that's something to be rewarded. That, oh, I lied. So because I have admitted that I lied, you should put that in the good column. Forgetting that she lied to start with, and she lied to cover up the killing. And so she indicated that to this officer in a telephone call, and by this officer I mean Detective Esteban Flores, that she knew the code to his garage, 0187. And so she knew the code to the garage, and she indicated that that's how she came in. She didn't knock on the front door. She didn't go out through the back and peep through the sliding glass doors like she'd done before. She actually walked in. There's no indication that Mr. Alexander came to the door. And this was sometime after 4 o'clock in the morning. And as she came in, one of the things that's telling about what happened is that she said, I came in and I stood by the door and I watched him. And I watched him for 30, 45 seconds. Who does that? Who comes in and stands there? Someone with some sort of stalking behavior in their past? Someone who's arriving there unannounced? Someone who is there to surprise Mr. Alexander. Mr. Alexander happens to be awake. He's got the dog Napoleon with him, and the dog barks, and there's this hello, how are you kind of thing. And at that point, she says that either she does bring her stuff in or she doesn't bring her stuff in. She may have brought her camera at that point. And we also know that she brought in her purse. And her purse is big enough for this toy-looking 25 caliber handgun. It's also big enough for a knife. She comes in, and according to her, they go to sleep. There's no sexual activity between them at that point. If Mr. Alexander was this sexual fiend that she has attempted to portray, why didn't he just force himself on her there? And she said, well, at that point I told him that I was tired and that I did not want to have sex. So whenever she said no, Mr. Alexander abided by that. The only time that she ever indicated that no, she didn't want to have sex with him, he abided by that. And they went to sleep until the next day. The next day, they do engage in some sexual contact. And there's such a stigma that the defendant has attempted to attach to this particular encounter. In fact, she goes so far as to speak with Richard Samuels, Dr. Richard Samuels, and tell him about this, and tells him that these photographs were actually taken while she was straddling Mr. Alexander. Additionally, she talks about how Mr. Alexander has on his computer all these photographs of women's breasts. Just has to add all of this to make Mr. Alexander be something that he is not, or have this encounter be something that it isn't. He did not go to Wairika to seek her out. She drove here to the state of Arizona, to Mesa, to see him. Yes, he did have a camera, and yes, it was used, and thank God he had the camera, because that's the reason why we're standing here, because of the images captured on that camera. And so they engaged in this sexual contact. And there's this, again, this religious sort of overtone, somehow that she's holier than thou, that it was all of his, at his request. It was all about him. It was nothing about her. And that he's somehow violative of the concepts or the precepts of the Mormon faith. Why is that important? It's important because she wants to manipulate you. She wants you to believe that, wow, he's such a bad guy. He's holding himself out to be a virgin. And somehow that's really, really bad. That when people date, or when people talk about their sexual lives, they somehow don't want everybody to know everything that's going on. If you remember, Deanna Reed indicated that, yes, they had transgressed. They had engaged in sexual contact. But they went to see the bishop. They got whatever penance or whatever punishment or whatever happened, but they never engaged in that contact again. Somehow the defendant wants to make it seem that Mr. Alexander kept constantly going. He was this individual who had lost his priesthood or had not, had or had not. And somehow that this encounter was a microcosm of their whole relationship. Well, if it is a microcosm of their whole relationship, then we have the willing partner sitting right here. Somebody who enjoyed it just as much as he did. One hand or two hands, she enjoyed it as much as he did. There are no indications in those photographs other than from their experts who say, look at the face. You can tell by the face that she really doesn't want to be there. Really? Can you tell by a grimacing face whether that's pain or joy? Can you tell that by just looking at somebody's face, especially if we're talking about a sexual situation? You can't. But they come in and they want to tell you that because they have a psychology degree or they have a master's degree. And they want to tell you that. Don't believe what you see in your eyes. Don't use your common sense or the experiences that you have coming in here. Believe what we have to say. And by looking at those photographs, you can see that this was all about Mr. Alexander. And again, that's just a microcosmic view, if you will, of this whole relationship where she says, I really never wanted to do it, but it was all about him. And yet, if you look at the photographs, there's no indication there that she really didn't want to do it. She was enjoying it as much as he was. And so they engage in this conduct, these two Mormons. So stop pointing a finger at him and stop wagging it as if somehow being a Mormon precludes you from being human. So stop pointing a finger at him and stop wagging it as if somehow being a Mormon precludes you from being human. If somehow that's something bad that he did it, because she's just as Mormon as he is. So if there are fingers to be pointed, it should be pointed at each other. And if one's conduct is bad, the other one is just as bad. But that's not what this case is about. And they want you to think that that's what this case is about, that this is about Mormonism and the fact that Mr. Alexander was engaging in sexual intercourse. What those photographs show was that she was there. And they show you the time that she was there sometime after 1 o'clock in the afternoon. And so you know that at about 1:30, they are consummating, if you will, their feelings for each other, at least on a physical level. No indication there of anything else other than perhaps Mr. Alexander has adopted what the defendant has provided for him, because you do see the KY bottle in some of those photographs, and you do know who introduced that into the relationship from the May 10th, 2008 conversation where Mr. Alexander thanked her for introducing him to that. We don't know who brought that on that particular day, but it could be reasonably inferred, we're not saying that it happened, that she brought it. She's the one that introduced him to it. Perhaps he already had it there. Either way, that's symbolic, if you will, of her attentiveness to this sexual, perhaps he already had it there. Either way, that's symbolic, if you will, of her attentiveness to this sexual relationship that they had. And so, later on in the afternoon, toward getting later, sometime after 5, the defendant says, and it depends on what you listen, or what version you listen to, that at that point, Mr. Alexander wanted to show off his body, according to her. And he wanted her to take photographs of him. You've heard the tape of her conversation with Detective Flores. That was taken and how she loved the way he shaved because it was old-fashioned. And then she starts talking about how, yes, she is able to get him to get into the shower and take photographs of that. And it really is. And then she starts talking about how, yes, she is able to get him to get into the shower and take photographs of that. And it really is more of her idea than his. And the only reason that the state can say that it is really more idea than his is if you hearken back, think back to what Darrell Brewer told you. One of the things that he was asked on cross-examination was, when he was on the witness stand, were there ever any photographs that were taken of you by the defendant? And he said, yes, only on one occasion were there photographs taken of me. I didn't want them taken. I was in the shower when she started to snap the photograph. Wanted me to do it when, as part of the same case, you have her saying that, no, he did not want her to do it. But she then starts taking photographs, and according to her, very sexy. But at that point, the ill will was already there. She is armed with both a knife and a gun at that point. And she begins to take these photographs. And as she takes these photographs, even though she says they are of a Calvin Klein kind of quality, the water coming down as if it was sort of a Pacific, a very quiet, bucolic kind of scene. That's not what's going on. She talked earlier about a knife, justifying how a knife would have been upstairs by saying that there was this 20-foot rope, and that somehow she was tied up with that 20-foot rope to that bed. And it depends on who she's talking to as to whether or not she was tied on her ankles as well as her wrists. But you've taken a look at that sleigh bed. Where is she going to be tied up on that bed? Making it up, trying to justify or trying to have a knife there for some other purpose. But if you take a look at that bed, and you've seen it, you know that she's making it up. Just making it up. If she's not making it up, then why has she told some of the experts that she was tied by her ankles around the foot of the bed? Why does she tell somebody else that it was both her ankles and wrists? Why does she need to keep changing positions? Because she has a lot to remember. And with the truth, you ain't got nothing to remember. But she has a lot to remember. And it's a lot for her to keep straight, given that she's making all of this up. And so, given the facts as we know them, and the fact that there was no rope, because it would have required her to clean up in the bedroom, because that's where the rope was. And if she was all bloody, because we do know that the floor was all bloody, it was also very wet. It was either wet with water, which is white, or it was wet with blood, which is red, Mr. Alexander's blood. It would have required her to go into the rest of the bedroom and leave some trail of that. And there's nothing there. So it means there was no rope there, and there was no knife there for her to get. It means that she had both the knife or at least the knife at the time of the attack. And so what happens then is that she's standing there, and then we have this photograph. Exhibit 160. This is the last photograph of Mr. Alexander. There, not only is he defenseless, he does not have a gun, he does not have a knife, he doesn't have any weapon whatsoever. Not only does he not have that, he doesn't have any clothing on. And as he sits there, he doesn't have any dignity either. She's taken that away from him. And if anybody, and as he sits there, doesn't have any dignity either. She's taken that away from him. And if anybody is defenseless, in this case, it isn't the defendant. It's Travis Alexander. As he sits like that, in that shower, with his killer standing there dressed in pants, presumably a top on, because there's no indication that she didn't have a top on, with his camera. And she starts snapping this. Part of the story of hers that you would have to be in the sharpness of this photograph. There's nothing accidental about this. Somebody held the photograph, or the camera, firmly. The defendant held it firmly as she pressed the button and took this photograph. The last live photograph of Mr. Alexander. And while she had that in that position where he is in the inferior position to her, he's down. She's standing up. She can approach him. And she can approach him as he's sitting there. And she did. No doubt about that. This is not a case of whether or not there was an attack here, whether or not it wasn't her. It's her. And it's him, and it's the man that she has just had sex with, and it's this individual that she has planned to kill all the way from May 28th of 2008, days, even though the premeditation statute only requires a certain period of time. It doesn't require days, doesn't require planning, it requires thinking. And so, she's been thinking about it for a long time because she came very prepared. And before she even went in there, one of the other preparations that she took was to take the license plate off the car. So now she's inside. Now she's got him like that. Can anybody think of how anything else could be so much colder or without feeling for the person than to make...
Objection, Your Honor. Your Honor, no further argument.
Approach.
It is cold. It is thinking. It is premeditated. To go up to this individual, someone that she has planned to kill for days, someone with whom she has been intimate with, and then attack him. She has indicated to you that it was a shot to the head, but the evidence, the forensic evidence, speaks otherwise. And for you to believe her, and for you to believe that the shot was first, you will need to set aside everything that she's told you, for example, the gas cans, everything else that she has told you, including the fact that she lied to the police, including the fact that she lied to the experts, including the fact that she lied here. And then you have to say, even though she's lied all of these times, even though she's looked us in the face and lied to us, we're now going to believe her with regard to just this one particular aspect. That is not something that is available to you, I submit. And I submit that because of everything that she has said. And so she gets her knife. And she took that knife and stabbed him right in front of him. The reason that we know that she did that is because Mr. Alexander has defensive wounds. And he has defensive wounds to his left and to his right hand. As she is stabbing him, he is alive and he is cognizant of it, and he begins to grab at the knife. But unfortunately for Mr. Alexander, one of the knife wounds is to the heart. Doesn't mean he's going to die immediately. It means he's just going to die. And part of the dying process includes, because of it's the heart, blood coming from his mouth and blood coming out from the wounds. But he's not going to die immediately. He's going to take some time, minutes, to bleed out. But he is going to die. So in a sense, she has already killed him. He's dead. Well, you know that he gets up at some point. You know that he doesn't remain seated there. Because throughout the bathroom, or where there's the mat, where there's the scale, all around the bathroom, everywhere, there's blood. And if there's blood everywhere, that means there is movement there. And it isn't the kind of movement that is the flopping of the fish kind of movement. It is movement, it is purposeful movement on the part of Mr. Alexander to save his life. And as this time is going by, again, premeditation does not take days. Premeditation does not take a plan. Premeditation just takes time. And it can be a shorter amount of time. The stab wound, for example, after the first stab wound, it could be that. And as he is in this position of dying, he then ambulates. And we know that she didn't carry him over to the sink. We know that he goes there by himself. And one of the things that you see there is this, 98. That's the sink. And that's the sink with his blood on it after he has been stabbed. The reason that you know that he has already been stabbed at this point is because of the patterns that you have on this particular photograph. Right here on the left. And remember the injuries to the hand. He had more stab wounds to the left hand than he did to the right hand. And one of the patterns that was described here was this smudge or this transfer. So that if he, and remember, he had more injuries to his hand. That's not something that she can tell you he doesn't, but you've looked at the photograph. You don't need to believe that. You can believe the photograph. And he does have an injury, a slight injury to his right hand. But if he's standing here, this would be where his left hand is. And you can see that there's the smudge or the transfer as he moves that way, as he's falling, moving away, indicating movement. He's still alive, but he's bleeding. That red stuff there, it's blood. And you also have the drops here. And those are placed there by gravity. If this individual has blood in his mouth, and if you remember that the medical examiner testified that if you do have an injury to the heart, that's one of the things that happens. And it requires Mr. Alexander to be standing there with his left arm like this. And as he's doing that, we do know that this is what's happening to him. She is stabbing him in the back. That's exhibit number 192. That's a concentric area. Exhibit 193 also shows us that. And he's also being stabbed, as you saw, in the back of the head as he stands at that sink. Because he is standing at that sink and he is bleeding, and the amount of blood that's at that sink is indicative of time. You just don't go over for a second and get those patterns. He stood there, which means that the defendant was there with the knife, stabbing him. The other pattern that you see there is this, on the mirror. If you remember, the blood spatter person indicated that, well, yes, that can happen from, for example, gunshot wound, but it can also happen if somebody has blood in their mouth and they get hit in the back of the head. And that's called blood spatter, high velocity splatter. And what that means then is that Mr. Alexander was having some force applied to his head at the time that he was standing there. That's how you can know that Exhibit 193 occurred when he was standing there and the strikes to the head. Because the splatter that is on the mirror indicates movement. Hitting him. And then he goes and flies into the mirror. But he's not dead. He's still standing there. This woman came to visit him, came prepared now. So he begins to go in a different direction. And we know that he begins to go down the hallway, and he's still standing. The reason that we know that he's still standing is if you take a look at Exhibit 133. That's a blood transfer. It's either an item with blood came by or the blood was already there. Well, the item with blood in this case was Mr. Alexander. And as he's going by, you can see he was still sort of standing. And in this rainbow, somewhat ironic, there is no good luck for him at the end of that rainbow. But you can see that it starts high and it arcs down to the area where there's the larger amount of blood. He's stumbling now that way. But he's stumbling with somebody after him. He's trying to get away. He's trying to get away from her over there. And she may cry now. But the jury instructions have told you that sympathy is not to be considered in this particular case. No doubt that she did it. No doubt that he's trying to get away from her. And you can tell that by the arc that is there. You can see that even clearer here with regard to Exhibit 132. That's the same view. Let me show you the arc there. Just for contrast, to show you that that was part of what was going on, if you take a look at the other side, the other wall, you can see that these are more at the bottom, indicative of substance with blood either rubbing it there or the blood already being there and an item going through there, as opposed to this arc that we see here. She chases him down. That's what she did. He's still alive. How many stab wounds has she already given him at that point? The ones to the back? Do we really need to count the number of stab wounds to get? Is there a requisite number to get through the portal of death? No, not really. There's enough here to get him there. He's already got the one to the chest, which is going to kill him. He's already got the ones to the back of the head. They're not failed. And he's got the ones to his back. But they are accelerating his departure from Earth. Because the more he bleeds, the quicker he dies. You don't die immediately. And so, when he gets here, to the end of his rainbow, gets there to the end. And when he gets there, that's what she does. This is exhibit number 205. Slits his throat from ear to ear. Number 205. Volition, by his own movements, as he tried to get away from her. You know that because of the bloodstain. You know that because of Exhibit 130, which shows you. And remember, the rainbow is right above there. He goes down, he collapses there. She catches up to him and goes for the throat. Is right above there. He goes down, he collapses there. She catches up to him and goes for the throat. And if you want to believe her that she doesn't remember anything, doesn't know anything that's going on, why then? Why then, if she really doesn't know what's going on and can't remember, why is she so directed at a place where she can certainly cause death? If she really didn't know what was going on, if it was just really passion, if it was just a heat of passion, then you wouldn't have a directed hit to somewhere that's going to kill. You would have dispersed all over the thinking, this person's not going to live. He may get away from me in the shower. He may get away from me all the way to the sink. And he may stumble his way down that hallway. But you know, I caught him. And now, rather than stabbing him anywhere else, right here. So it's a very well orchestrated kill. And it takes time. By time, when somebody takes time, people think. So she's now stabbed him in a die. When somebody takes time, people think. So she's now stabbed him in a die. And now he's tried to get away, went to the sink, and what's almost something to consider. Another thing to consider while he's at the sink is that in front of the sink is a mirror. And as he's standing there, a mirror is reflective of what's going on behind him. He has eyes. His eyes are still open at that point. He can see. He can see the defendant. But she's not done with him yet. And again, the point here is that if this were a heat of passion, if this were a situation where somebody was just upset, it would be random all over the place. But this was a strike to kill, right at the neck. And then, after she does that, one of the things that we know is that the shooting didn't take place there. The shooting took place near the sink, where he had previously been standing. And so, one of the things that they wanted you to believe was that if this person is shot and hit through the head, could have been shot there at the sink, according to them. It's already bleeding and still continued on. But the knife wounds do have to be first. Of course, that would violate the laws of nature, because he's bleeding so profusely there that the doctor, by necessity, would have had to have found lots of blood in the track of the bullet, and he didn't. So if he was standing at the sink and he was shot at the sink after being stabbed, there would be lots of blood there, and the doctor did not find any there. So he clearly was shot after that, when the situation was such that his heart wasn't beating, in a situation when the heart wasn't pumping enough blood to get it there. Bottom line, he was dead at the time that he was shot, in order to forensically get the result of no blood in the track of the bullet. So he falls there. And then we have more directed behavior. We have this, exhibit number 162. That's Mr. Alexander, that's blood, that's his foot, and that's her foot. And given the fact that we know that the bathroom is this way, that's her standing there. And what's important about that, if we look at this exhibit here, is that it looks like there's been a wildebeest migration near his head. Look at that. And what's important about that is that even though there is the stomping of the feet, it just means she was over him, hovering him. How many times was she stamping around or stomping around there to get that pattern? But what's even more important about that is that there's nothing in the bedroom, which means that this was directed behavior at him. She was cognizant of what was going on, because if she would have been in this state that she wants you to think that she was in, then it would have been all over the bedroom. If she'd have been in this hysterical state that she describes for you, that she would have run out, run into the bedroom, except it's in pristine shape. So what she does then is she begins to drag him. And again, we look at that one, and then exhibit 163, which is a bit later, you can see she's dragging him down the hallway. What that shows is an attempt to clean up. And as she's going by the sink again, you know that she does something else. What she does is this, exhibit 207. Shoots him in the head. There is no blood in that blood track, which means the heart isn't pumping. And when the heart isn't pumping, he is dead. There is no other medical phenomenon or any other medical indications that would give any other indication. And if that's the case, then he's already dead. And then you have the casing from the .25 caliber handgun that you took during this staged burglary. And then you have the casing right there, falling on top of the blood as she's dragging him back, because by necessity, the body has to be there. And if you remember, there's a closet that's up here, the sink is to the left, and the sink is to the left, and this falls to the right. One of the things that we've talked about is that the shot just right here, if she is dragging him in this fashion, that way, and she's pulling him along here, that would mean that it would be this portion of the head that was exposed, which if you're pulling somebody down the hallway, that's the result that you get. The casing is expelled and it lands on the blood that's already there. So that's when she delivers this shot to him, somebody that's already dead. So she's killed him 3 times over. Is that enough premeditation? Even though she's got all of this planning already, this was a very directed attack. And then she goes about the business of cleaning up. And one of the most interesting things about the cleanup that she did is that she knows about cameras. She knows what to do with cameras, according to her. And one of the things that she knows what to do with them is delete photographs. And she's able to look at all of the photographs that are on this camera. Let's assume, for example, that they've already deleted the ones involving the sex. This one right here, the inadvertent photographs, Exhibit 162, for example, had to be deleted after he was dead. There's no way to get it. There is no time travel here, because that's really what they want you to believe. After this happened, she located the camera. And he's not carrying the camera as he's trying to survive. He couldn't care less about that camera as he's standing over the sink. So what does he do? He just tries to get away. So the camera getting there means that she is the person that was holding onto the camera and carried it to that location. Then, after she shoots him, she goes back, places him in the shower. At some point, either after shooting him at the sink or after placing him in the shower, at some point, she's still thinking. Because remember how much she has planned before. I've got to get rid of this evidence. I got to delete this. And what does she do? She deletes only certain images. It's not like all of the images are deleted. This shows somebody who is thinking, oh, I don't want to delete the one of his dog or this other one. I'll delete the only ones that hurt me. And that is directed behavior by somebody who claims to have dissociative amnesia. Dissociative amnesia, you heard what the definition of that was. Or is it a fog? Even the San Franciscan fog, if such a thing existed, wouldn't be so cloudy to account for this kind of behavior. There is no fog that someone can tell you about that hasn't lifted to allow for this. And so she cleans that up. She has that, and she cleans that up. The other thing that we know is that she takes the camera at some point from that area there. And again, what's important about that, yes, it's important where it was found, and yes, it's important that it was found in the washer, but what's actually more important to show that she was thinking is that there are no steps leading from the bedroom down to the area where the camera was found that are bloody in nature or red, which means that she was cleaning herself up. Because if you're going to be walking around there, you by necessity are going to get it in your socks because that's what she's wearing. She would have had to get it on her socks. And if she's in this horrific hysterical state, she would have ran down and thrown it down there. But what she did is she cleaned herself up first. The police did not, and you looked at all the stairs, did not find anything that showed that there was any activity other than up in the bedroom, which means she cleaned up. She took her socks off and then maybe put her shoes on or maybe put different socks on. But definitely the item that she was wearing was taken off before that camera was taken downstairs and put in the washing machine. And it was put in the washing machine and put through a cycle. Oh, there's this big indication, or there's an indication she could have taken it with her. So, what does that mean? It just means it's an alternative. But she has done so much already. Other things that she has done, according to her, is there was this glass underneath the sink area. And that's the glass that's found on top of Mr. Alexander after she cleaned him up. After she cleaned him up in the shower. We don't know if the glass was an afterthought or if it was used to actually clean him, but actually shows that she went to the sink, approached his body, and dropped it on top of him. But she cleaned him up, wanted to wash away anything or any contact or anything that would show her being there. Again, we're told about what DNA is and how it's left behind. But if somebody washes it away, it's just not going to be there. And that's another step that she took in staging this scene. She washed away all of her DNA from him. Could have turned on, we don't know if she turned on the shower. We don't know if she used the glass. but we do know that she cleaned up. And it isn't because she loved Mr. Alexander that she cleaned him up. Oh, it isn't that she wanted him to look good, even though he, with all due respect, he looked a little bit crunched up there. It wasn't that. The net effect of what she did is to destroy any of her DNA. She washed it off. That's what people do when they want things that, such as items off their hands, they wash out. And that's what she did. And then we don't know what was in the middle of the bathroom that was causing her concern. But we know that she focused in on the bathroom area as well as near the closet. Again, we don't know exactly what was there. Perhaps that's where she dropped the knife and she needed to clean the knife there, because we know that the knife was cleaned. We know that the knife was not left behind. So again, there's this directed behavior with regard to the knife. Had the knife been dripping blood, and remember, she had just stuck it into his neck. Had that been happening, and had she been in this hysterical sort of mood that she wants you to believe, it's fair to say that that knife would have been bloody, she would have dropped blood along the way. No, she carried it out. She wants you to believe that she may have carried it down to the dishwasher. If she did carry it down to the dishwasher, which the state disputes, but we can use that for demonstrative purposes to show that knife, if it was carried downstairs, either had to be cleaned up upstairs or wrapped in something like a towel, which shows again directed behavior, so that no blood got on any of the stairs. Didn't get anywhere else. So if she says, which is what she said that sort of alluded to, that maybe that's what she did with the knife, because no knife was found up there, and we do know that a knife was used in this attack. If she did that, she did something with the knife. She either cleaned it, stuck it in her purse, or according to her, even if you put it in the dishwasher, but she can't be sure about that, the behavior before the movement of the knife shows that she was thinking this whole thing through. If you step back and you say, what was she thinking at the time? Well, she was thinking of staging the scene, cleaning it. That's what she was doing. She cleaned the body of any DNA. She cleaned the area where it appears some of the attack occurred. The other implement, the knife, that was clean because it wasn't found or dripping anywhere. The gun, well, it was taken. The clothing that she had on her, specifically the footwear that you see in Exhibit 162, that wasn't found anywhere. There was no bloody socks anywhere. And even the towels that were upstairs, if you remember, there was one towel missing from the set, was taken down and placed inside of the washing machine, and the cycle was run. It appears that the cycle was run with Clorox. And what's significant about that is that, yes, it's significant that Clorox was used, but what's also significant about it is that the hands were clean at the time the Clorox was grabbed, because otherwise you would have seen the handle with blood on it, you would have seen blood all over the washer. You didn't see that. She had already cleaned up upstairs, and she was cleaning up because she did not want to get caught. And it was actually, as plans go, pretty good, except for the photographs. So she's now staged the scene. She's now cleaned up. There has been days of premeditation, but if you just take the scene itself, and we will discuss the jury instruction that tells you that it just requires a space of time. And killing somebody 3 times over has built into it a space of time, irrespective of which event you think happened first or happened last. It's the state's position that the stabbing happened first because of the forensic evidence and the blood spatter evidence that's upstairs. Either way, she killed him 3 times over. She stabbed him in the heart. He would have died from that. Certainly the throat was immediately fatal, and the gunshot would also have been fatal. So there is this premeditation aspect. And so she staged the scene at that point. Then she did some other things that were equally as interesting. And by interesting, I mean demonstrative of how well she was thinking at the time. She claims that she was in this sort of foggy state She wasn't in such a foggy state that she couldn't put the license plate back on the car that she was driving on the back. She was in a hurry and put it on upside down, but she had already taken it off before and remembered to put it back on, such that she drove all the way to Utah that way and was stopped in West Jordan, Utah. So yeah, she was thinking there. She wasn't driving without a license plate, because police officers would have stopped you quicker without a license plate than one upside down. So thinking there. The other thing is she packed up the clothing that she was wearing. It was bloody. The socks included. Packed all of that up and took them with her. Cameras, her purse, the gun, all of that. She was cleaning it up, staging it up for the police, so that when the police went up there, they wouldn't even know what was going on. Got in the car, did all the cleaning, and was sure and careful not to get it anywhere other than the bathroom. Walked out, and on that hot summer June 4th, got into the car, left Napoleon behind, and started to drive away after putting the license plate on the car. And, according to her, at some point, filling up with gas from the gas cans. If you're in such a fog, how can you even remember that you have gas cans? How can you possibly even remember that you have a gas can if you've never done it before? And she, according to her, this is not something that she did on a usual basis.
Objection. Facts found in evidence.
Overruled. The jury is directed to recall the evidence.
And away she goes down the road until, according to her, she stops on the side of the road, starts calling Ryan, and continues her lies. Starts calling Ryan and gave a story about where she had been. She lied to him. She wanted to continue that, speaking with him, because he could potentially say, well, no, she was with me. She was somebody that was with me at the time. So, again, she's continuing to stage the scene for the police. What else does she do? If she didn't think that she had killed him, then why is it that she's calling and leaving a voicemail message as soon as she possibly can? Oh, I'm sorry, I couldn't stop. If she was really in this state of fogginess, you would have heard some mumbling, or she wouldn't have been able to work the prompts on the phone. But she was able, according to her, keep going back and try to do the message. 1, 2, 3, 4. How many times did she say? Many, many times. She said she tried to do that. That shows some clarity of thought. And of course, though, she wants you to believe that there was no clarity of thought. She wants to manipulate you, wants to continue to lie. Why send an email? If you really didn't know what had happened, why send an email? Why not call the police? And why continue on your journey to make it seem normal? Why continue to make it seem normal? As if nothing had happened. The reason that you do that is because you had it planned. Ryan Burns was nothing more than her alibi. She showed, maybe he was a little bit more because of the interest that she showed. But she calls him up, makes up this story about where the cell phone has been, and continues on to Utah into his waiting arms. Gosh, you could almost hear the violins making their sound as she goes up to him, gives him that first kiss. Isn't that romantic? And then later on, as they kiss passionately after going out, and she adjusts him, whatever that may mean, although according to her, he's full of crap. Anybody that doesn't agree with her, oh, they're full of crap. Those are her words from the witness stand. He's wrong. And he's not telling the truth according to her. He doesn't have anything to gain. But he does tell you that, yes, they were involved, and they were involved in a sexual fashion when she gets up there. What a wonderful reunion, what a wonderful time it must have been for her. And so then, there's this talk that she has with her friend Leslie Udy. And she begins to talk about the future with Mr. Alexander in it. How this Mr. Alexander that is going to be with her in the future after he's married and he has kids. She's married, she has kids. Their children are going to play together. Absolutely staging the scene again. Continually staging the scene so that if the police start making inquiries, guess what? Well, she didn't know he was dead. Boy, she was just normal with me, Mr. Burns would say. And with Leslie Udy, oh, she was talking about the future. Again, she's just staging the scene after what she has done. at the restaurant that they go to. There's this talk about her hands, and she, again, makes up a story as to how she got the injury to her hand, even though it's from the knife slipping as she was knifing Mr. Alexander to death. And then afterwards, her friend, Dan Freeman, calling her on the telephone and telling her, oh, his body has been found. And she, crying, then calls the bishop, trying to determine whether or not he was alive. What an absolute facade. She's creating a wall of excuses, a wall of absolute, what appears to be impenetrable might, so that no one can assail her. No one can say that she had anything to do with this, because she's acting the part. And she's lying. She's making it all up. She has lied to everybody, and she has staged the scene. She staged the scene of the murder. And then she came into court, and during these proceedings, has staged her defense. And she staged her defense by lies. And the lies that she told were to a number of people and to various groups of people. First of all, let's start with you. Perhaps it may be that in court, because of the admonition and standing in front of the clerk, that somehow that would bring out the truth, because after all, this is a truth-finding sort of proceeding. Well, let's start with some of the examples that we can talk about that we know that she lied to you about. This issue about the gas cans. Absolutely, without a shadow of doubt, she's a liar. And she's a liar about, number one, that she returned it to Walmart. And she's a liar about the fact that she didn't have them with her in Salt Lake City. It's just a lie. And the reason she's lying is that that explains why there are no receipts here in Arizona. And that also goes to premeditation. She planned to come and kill Mr. Alexander with that .25 caliber and that knife from May 28th on. That's what the evidence shows. One of the things that you can say to yourself, well, you don't have any direct evidence of that. That's true. We have circumstantial evidence. And circumstantial evidence is a fact that you can deduce from looking at the circumstances as opposed to direct evidence, which is visual or hearing, sensory kind of evidence. The best example from looking at the circumstances as opposed to direct evidence, which is visual or hearing, sensory kind of evidence. The best example, no matter what time of year it is, and you're there by yourself. And you're standing there and you're watching the waves come in. As you stand there from your left, somebody walks by and then goes to your right. A minute or so later, somebody else comes to you and says, has there anybody else been on this beach? And you can say, sure, I just saw him walk by. That's direct evidence. Well, contrast that with circumstantial evidence. You are at the same beach. You have not seen anybody go by. You have not seen any fingerprints. You haven't seen anything. And you decide that it's a nice day and you're going to close your eyes. With circumstantial evidence, you are at the same beach. You have not seen anybody go by. You have not seen any fingerprints. You haven't seen anything. And you decide that it's a nice day and you're going to close your eyes. You have your Wayfarer sunglasses on. You have your towel out. You're going to lay down and you close your eyes for exactly, let's say, a minute. And before you closed your eyes, you noticed that there were no footprints here, no footprints in front of you, and no footprints there. And the ocean's not coming up to you. Close your eyes and you wake up, and when you, for those 45 seconds or so, and then you look, and to your left is a set of human footprints. You see it goes right in front of you, and then it goes by. You didn't hear anything, you didn't hear anybody, but you can say yes. And the reason that you can say yes is because of the footprints that you saw after you woke up. And the same thing here. There are many footprints to this premeditation aspect. One of the footprints that we have is up in Wairika, California, after the May 26th, 2008 argument where he tells her, you're the worst thing that ever happened to me. Then you have her stealing the gun, or the gun is stolen, and it's a .25 caliber that's actually found at the scene. After that, you have her borrowing some gas cans. And then you have her lying about those gas cans. And then you have her lying about the license plate. And you have her turning off her phone so that she can't be found in Arizona. And then you have the photographs, and you have the rest of the evidence in this case. She premeditated the murder in this case. The other thing that we need to talk about in terms of what she told you that is not true is why she rented the car in Reading. She said, oh, that's the place that Priceline would give her the best deal. But you saw the receipts, not the receipts, but the statement from Washington Mutual that indicated that, hey, she paid directly to budget. So that wasn't a Priceline thing. She looked at each and every one of you, and that's what she told you. Well, that's because, of course, she's innocent. And you as a jury are not going to convict her, right? The other thing that she talked to you about was this injury to her finger. She said that she showed you the finger and she demonstrated it to you. And she said that Mr. Alexander had been the person that actually had done that to her. Well, if you remember during cross-examination, when she was being asked about what happened in her killing of Mr. Alexander, the question was, well, you really didn't get any injuries. I mean, aside from the injury to the head, do you remember? That's all that you got then. And then she said, oh no, I also got the injury to my finger. Do you remember her saying that? In a moment of candor, in a moment when she wasn't quite expecting it, she said, yes, that's when it happened. Yet then she turns around and says later, no, that's not how I got it. I got it working for Casa Ramos, Margaritaville. I got it at his house. Who knows? But she looked at you straight in the face about an event that occurred at the time of the killing. And she looked you in the face, every single one of you, after taking the oath, and lied to you. Maybe this law of attraction, maybe something else, maybe that will explain it, or maybe her experts will explain these three areas that you know were made up. She just made them up to you. And why did she make them up? Because although she says no jury will convict her, it's because she's attempting to get you or manipulating you to get to that particular point. One of the other things that perhaps we need to look at or talk about is their experts. And with regard to their experts, and with regard to the defense that's presented, one of the things that perhaps you can sort of allude to and maybe make reference to when you're looking at this particular defense is by reference to Elizabeth Barrett Browning in a sonnet, where she indicated that, and again, it's just a reference to it, how do I love thee? Let me count the lies. It's a little bit of a reference to it, but that's not exactly what she said. But really, how do I love thee? Let me count the lies. Well, we've counted 3 so far that in this court, looking at each of you, she said that. What else can we look at? Well, perhaps we can look at the motivation, or perhaps we can look at people that have testified on her behalf, and maybe we can understand what's going on. We can talk, for example, about Alice LaViolette. She's the person who has a master's, who came in and has been doing this for a long time. And one of the things that Alice LaViolette has, and she has an extensive CV or resume, is one of the things she hasn't included in there is that she is also a liar. That is just the bottom line. She came in here and she told you, in response to one of your questions, about whether or not she had ever testified on behalf of a male in court. And she said 1 or 2 times. Remember that? And when she was pressed by the prosecutor during cross-examination, well, who are they? Couldn't give me the name. Give me a name. Go ahead, give me a name. Pressed even further, she said, well, I didn't testify. I actually wrote a report. She wanted to make herself more than she really was. She also talked about being a keynote speaker at one of the conferences where was Snow White a battered woman. She indicated that she was one of the keynote speakers there at one of those conferences, and she wasn't. Her CV indicated that she was on the plenary panel, which is just part of people that go there, and she made a presentation to a smaller group. And just as importantly with regard to lying and Alice LaViolette, she indicated and tried to justify the defendant's lies for you so that you wouldn't think that they were so bad. She kept saying, well, she lied before, but not afterwards. And we got into this conversation about lying, and Alice LaViolette said, well, you know, bad. She kept saying, well, she lied before, but not afterwards. And we got into this conversation about lying, and Alice Laviolette said, well, you know, there's such things as white lies. Those are okay. See, you don't understand. For her and for the defendant, white lies. White lies. They're okay. And if it's to her benefit to say that something is a white lie, she will say that it is a white lie. And in this case, everything that's negative towards the defendant, and it is untruthful, well, that's just a white lie, according to Alice Laviolette. And to her, that at you as an expert, because they're trying to provide guidance and say, yes, I have testified on behalf of men before, and then going back and saying, no, that's not true. Measure, but maybe that's a guide to the defendant. Maybe that's something that she, of course, believes. Maybe that's something that buttresses the defendant's case, and Alice Laviolette believes that that's something that she should do. But what that indicates is that she's nothing more than an advocate. When you begin lying on behalf of the person that you evaluated, when you begin to visit them, when you begin to give them books, when you're with them for 44 hours, that line was crossed. Anything Alice Laviolette said is contaminated. It is foul. It is not something that you should consider. Because how much credibility can you give her if she came up here and in advocating that position, she lied to you? Absolutely no worth at all. And then you have Dr. Richard Samuels. And one of the things about Dr. Samuels was that, in the issue involving lying, is one of the things that he did is that he had trouble with regard to this scoring and rescoring. And there were some issues as to really what the motivation was for the rescoring. Dr. Janine DeMarte indicated that, well, there's no reason to be rescoring something 3 times unless you perhaps want to change the scores. Or with regard to the MCMI, there's no reason to submit it twice unless perhaps you might want to change the scores. But one of the things that we do know about Dr. Samuels is that he gave the PDS test. And there is no doubt as to that test that the defendant lied. The defendant made it up. There is no truth to the fact that on question 14, number 4, that whatever seminal event that they're talking about, there was never any indication whatsoever that there was a guy and a girl that came in and killed Mr. Alexander. But he based his test on that. And the defense and the questions may be asked about whether or not it involved the attack of a tiger, or if it involved the attack of a bear, or if it involved a gopher. It doesn't matter. The bottom line is that it's a lie. Let's say that somebody goes to the doctor, and they go to the doctor and they're talking about some sort of pain that they have. And if they start lying about the pain, isn't the treatment going to be affected by it? How good is the workup going to be if the seminal event that you're there for is a lie? Well, yeah, you can say she suffered trauma. Okay, let's assume that you even go that far and say the PDS does show that she suffered trauma. Well, which trauma are we talking about? Is it the bear? Is it the tiger? Is it the gopher? Or, in our case, is it the trauma of lying about killing Mr. Alexander? Is that what we're talking about? Or is it the killing of Mr. Alexander that we're talking about? Or, as the other expert, Cheryl Karp, found, was it the trauma of this non-existent domestic violence? The problem is that when you start lying and the experts get involved and they start basing their test on a lie, how valid can the results be? For example, Cheryl Karp found that, yes, she believed it was post-traumatic stress disorder based on many, many events of domestic violence. Yet there are only 4 that were presented to you and never linked to post-traumatic stress disorder. Then there's this test of PDS that was taken, and according to Dr. Samuels, he said, you know what, I probably should have re-administered it. In a moment of candor, he said that. And yet he then reversed his position and changed it. But again, what do we have here? Another lie by the defendant. Not only to Dr. Samuels, but also to Dr. Karp or Janine DeMarte. Dr. Janine DeMarte. Either one. You can't have a lot of domestic violence or a little bit of domestic violence. So you have that issue that is sort of floating out there with regard to the experts. The other area that the defendant lied about was the police. Detective Ford? Oh.
All right, ladies and gentlemen, 15 minutes. Please be back at 3 o'clock. 15 minutes. You are excused. Please remember the admonition. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue.
We were talking about the litany of the defendant's lies, and we were at a point where we were going to talk about the lies to the police officers. And you've heard so much about that almost there's an effect such as, well, she did it. It's let's accept it and move on. But it is an important factor, not because it is important because she lied, but because of how it fits into her particular plan. And one of the things that we have to think about when we talk about lies is that, and you think about what she told the police officers, is that maybe there was some exaggeration that was going on with regard to what she told the police officer, or maybe there was some minimization that was going on. In terms of exaggeration, one of the points that needs to be made is that Robert Geffner, who was here yesterday talking to you, and said, well, exaggeration really isn't a lie. Well, it is, because it's not the truth. And so some of the things that the defendant told the police officer, well, exaggeration really isn't a lie. Well, it is, because it's not the truth. And so some of the things that the defendant told the police officers, somebody may say, well, no, that's a little bit of an exaggeration, maybe it isn't. But at the time that she spoke to the police officers, it had been something to think about what was going to happen if she spoke to the police. And so it's important from the aspect of somebody who's thinking about it, somebody who is planning. It shows that this individual had the forethought to have a story ready when the police officer came to her. And this individual is of such strong will that even in the face of what the police officer was talking to her about, she would actually not budge initially when she was spoken to by the police officer. For example, one of the things that she was asked on the first interview, well, isn't it true that you were there? And she kept saying, no, I wasn't even there. How could I have possibly done this if I wasn't even there? And then she was asked, well, isn't it true that your fingerprint or your palm, it was actually a palm print, but the fingerprint, isn't it true that the fingerprint and blood was there? And she said, well, of course it's there. I've been there all this time. And so it shows you the adaptability and how nimble this individual is, such that when she gets in any situation, whether it be involving Mr. Alexander or here in court, this individual is quick thinking and is good on her feet, and so that when she's talking to you on cross-examination and you get those answers are designed to manipulate. And so that's why those statements to the police are important, because they show how she can attempt to manipulate things and is able to say whatever fits the story at the time. So initially, when the police came to her, when Detective Flores came to her and asked her, well, this is what we have, let's talk about it. She denied everything. And she kept saying, let me see the photographs. I want to see the photographs. The reason she wanted to see the photographs is because she wanted to conform her story to what the police knew or what she thought the police knew. And in fact, in other conversations, during the telephone conversations, they discussed it. And that just shows you this type of individual that can adapt, if you will, as she's going along with the interview with the police officer. And in asking to see the photographs, it's interesting that she asks that. And the only reason that I mention it is because previously, when I was showing the photographs of the killing of Mr. Alexander, we had the defendant crying. Well, why did you want to see the photographs when the police officer was there? You knew what had happened, and yet she's still asking to see it. Again, it's just another form of manipulation to have you feel some sympathy for her as she sits there with the red nose, face down, apparently crying. But yet she asks the police officer, can I take a look at these photographs? Police officer, of course, did not show her the photograph. So the first story on July 15th wasn't even there. wasn't even there. Then has overnight to think about it, and on July 16th, changes it to something else, because it'll make much more sense. Because now she knows about a little bit about what they have there. She wants to now be able to say that she was there. But what does she do? She says, not just that she was there, but she makes herself the hero. Just switching it up. Not only does she say that she was there, but she makes herself the hero in the sense that she pushes the woman down and has the gun pointed to her head, and you know, by luck is not killed, but she's able to push people aside, and then she wraps it up by saying, but oh, you know, I wish I could have stayed there. I should have fought more. I did fight, but I should have fought more, and then away I went. Again, trying to paint herself, not only that she was there, but again that she was this hero, attempting to not only tell a different story, but to manipulate that story to make her look better. Years go by, and then we have the story that we have now. This non-stop litany of lies by the defendant just does not stop. She has lied to various groups of people. She has lied, as we said, to you. She has lied to the medical health care professionals. She's lied to the police. And she's even lied to the media, something that she has craved. This individual here craves the media, loves the media, went on national television to talk about this. And what did she do? Not only did she lie to them, but she made herself seem like such a calm person. Oh, I wouldn't do that. Didn't tell any of the things that we see here today. And of course, it's not a confessional when you go there, but it is demonstrative of the fact that she's a chameleon, and she'll adjust to the situation and make up whatever stories are appropriate for her at the time, whether it be the media or somebody else. The same can be said is true about her friends, the people that she has, the friendships that she has. She lies to them, and she does things that almost make you step back and say, what could you possibly gain by that? When, for example, she talks to Leslie Udy and makes up this thing about her kids and Mr. Alexander's kids playing together. She didn't have to go that far. The point I'm trying to make is that these lies are lies, but then she goes even further with them just to sell them, to manipulate the person into thinking that they are actually true. For example, with Leslie Udy, she could have just said, oh yeah, I speak to Travis every now and then, but then she adds, oh, but I want our kids to play together. When Dan Freeman called her, well, she didn't have to, after he called her and said, I don't know, what happened, but Travis is dead, she didn't have to then go and talk to the bishop. She does these things because she's such an ornate liar. It just has to add the extras to it to really sell it. And that's what she did for you. For all of those times, all of those days that she testified to you. And the reason that I bring that up, this ornate storytelling, is because it applies to her defense and her defense really is based on lies. It really is. And if you can say, for example, oh, she presented it as if it was in self-defense, but not only did she present it as if it were in self-defense, she added some ornate lies to it. For example, one of the things that she added was this physical violence that supposedly Mr. Alexander inflicted upon her. But she doesn't just say that he inflicted these 4 incidents of violence. She goes into great detail about it. For example, she talks about the one in August of 2007 where he goes upstairs and he's banging his head up against the wall, just very flowery, very out there, because then she's again the center of attention. She's being the calm one. She's being the person that is the individual that you would look to for the answers. It's not just the lies. She's a very good liar, but she, on top of that, is a very sophisticated liar in the sense that she adds these extra elements to it. And she did that with regard to the acts of domestic violence. And they are lies. If we are to look at her journals and sit back and take a look at what she writes, those journals tell you that there were no acts of domestic violence. Have you been given any reason whatsoever other than this law of attraction and other than another Alice Laviolette, somebody who has trouble with the truth. Other than that, vouching for them, do you have any reason to doubt what is being written there? Do you have anything that the defendant has said that has corroborated in terms of the domestic violence? You have the journal entries indicating that they did not happen. You have friends indicating that they never saw it. You don't have any medical reports, any police reports. You don't have anything. And as we get talking about these, there are lies, and then there are monumental, huge lies. And she made this up because that fit her defense. And one of the other things that she did with regard to this is that not only did she make up this lie for her defense, the other thing that she did is that she created a lie that really involves behavior that is a hot button kind of topic. How horrific it is to be accused falsely of being a pedophile. He's not here. He's not here to say, no, that's not true. She can say to Alice Laviolette that it was on computer, the images, but then Alice Laviolette comes in and says, no, that's not what she told me. But remember, Alice Laviolette has a problem with the truth. And so Snake goes to the computer and doesn't find anything there. Oh, no, I changed my mind. It was actually images. They were like this. And how does one defend that when there are no images there? The police looked through the attic. The police looked everywhere. How absolutely hateful. And how does one defend that when there are no images there? The police looked through the attic. The police looked everywhere. How absolutely hateful that allegation is, and how absolutely extensive she was with it. But remember I said that she went a little too far with these lies? First of all, her journal indicates that there wasn't such an event. Second of all, the text messages also indicate the same thing. And what human being, if that is the allegation, if they really are caring, what human being doesn't go to the police and say, or somebody else, this person is. What she does, well, it's the new approach. It's the new, and she talks about all these phone calls going back and forth, and that also doesn't match. What she does, well, it's the new approach. It's the new approach to pedophilia. What does she do? Well, let's jump in the sack. That's what we're going to do. At least that's what she tells you now. But with regard to Alice Laviolette, no, she didn't. She can't even keep that together. If that is the truth, and if that is what happened, wouldn't you expect that her journal, if she had it, if she didn't write about it, at least wouldn't have said that nothing noteworthy. It's fortunate that the police did have Mr. Alexander's laptop, and there weren't any images of children on it, none whatsoever. It's fortunate that the police did have Mr. Alexander's laptop, and there weren't any images of children on it, none whatsoever. They checked throughout the house. There was nothing inside of the house that indicated anything like that. There weren't any photographs. There wasn't anything. And so this allegation of hers, whether it was on the computer or whether it was in photograph form, just went a little bit too far. These lies to take from Mr. Alexander, the only thing that he has left, his reputation, it's just a little bit too much to, in light of what we know, in light of what she says, it's just too much even in this particular. That person does not deserve justice. That person doesn't deserve anything because of what he did. It's so easy for her to make these allegations. That person does not deserve justice. That person doesn't deserve anything because of what he did. It's so easy for her to make these allegations. It's so easy for her to get on the witness stand, as you've seen, and lie. And this is really the pinnacle. It doesn't get any higher or worse or lower, whatever way you want to look at it, than that. Well, how do you judge that allegation? Well, the judge has. How do you judge these sorts of allegations? Well, just like everything in this case, there are rules. And those rules are the jury instructions, such as the ones that have been read to you today. And one jury instruction particularly deals with this aspect. Witness's instruction. I know the judge has read it, but because it's so important, it is worth my referencing it because it directly witnesses instruction. I know the judge has read it, but because it's so important, it is worth my referencing it because it directly relates to the two primary allegations in this case, that of physical abuse and the fact that Mr. Alexander was interested in little boys and girls, according to her. It tells you that in deciding the facts of this case, you should consider what testimony to accept and what to reject. What it's telling you there is that you ultimately decide whether or not this person here, who is the epitome of a liar, whether this individual, whether you're going to accept or reject what she tells you. Are you going to pick and choose some things of what she says and then accept some other things? How is it that you can know with any certainty whatsoever whether or not she's telling the truth about anything? It says you may accept everything a witness says, or part of it, or none of it. The state submits to you that you are, based on what you've seen, based on what you've heard, and based on the testimony of others, that you should accept none of it. It doesn't mean that the 18 days that she was on the witness stand are wasted. No. What that means is that you're finally able to see this individual in the light of day. You're able to see how she reacts. Doesn't matter where. And this instruction then goes on and says, in evaluating testing every one of you in the eye and lie. Doesn't matter where. And this instruction then goes on and says, in evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life. Important matters. What kind of has lied to them consistently about major aspects of their life. You know, people would not go to a doctor who lies to them. And the factors that you are to consider are the witness's ability to see or hear. You know, people would not go to a doctor who lies to them. And the factors that you are to consider are the witness's ability to see or hear. The quality of her memory is incredible. Absolutely incredible. She was there. She knows. The quality of the witness's memory. The quality of her memory is incredible. Absolutely incredible. Down to follicles of hair. Unless it hurts her. Then the fog rolls in. Then there's an excuse. Then there's a reason why she doesn't remember. She has an incredible memory, all right, when it comes to lying. And the witness's manner while testifying, how it was that she testified, how it was that the defendant testified. Well, you saw her at times attempt to cry. You saw her at times get angry, to somehow make the person that was asking the questions the villain. Saying, well, you're scrambling my brain. It's not my fault. Again, it's not my fault. It's the fact that you're asking me these questions, just like Travis. That's exactly what's going on here. So that's not my fault that I keep lying here on the witness stand. It's yours. Because of the way you're asking me the questions, the fact that you're raising your voice. That's whose fault it is. And that's why I can snap at you from the witness stand. I can smirk at you from the witness stand and look knowingly towards the jury, because not her fault. It's the person who's asking the questions. Whether or not the witness had a motive, bias, or prejudice, if there is any witness in this case who had a motive to lie, it's this defendant. She's the person that's charged. All of the other witnesses that came here, some of them had a motive. For example, Alice Laviolette, she had a motive to lie. I mean, maybe perhaps it was her reputation that she was interested in, or and things like that. All the other individuals, for example, Ryan Burns, why would he want to lie about anything? He lives in Utah. He just met her at one time. There's no reason to believe that he was going to be making these things up. Amanda Webb, why would she want to come in here after all the work that she's done and make things up? The only person with a motive is the defendant. So when evaluating her testimony, that's something that you need to consider. When it's to her benefit, she's going to lie. Whether the witness, the defendant, was contradicted by anything the witness said or wrote before trial. Well, she wrote, for example, in terms of these two allegations involving the pedophilia and involving the domestic violence, that they didn't happen. Additionally, she never told anybody. And the reports out there, if there aren't any reports that would corroborate what she said. So, in terms of the pedophilia, well, she says it was on the computer. Well, the computer doesn't show that. And they even went back and looked and traced and looked everywhere. The house, there was no implements, if you will, or anything associated with that kind of conduct. And so in this case, nothing supports what the defendant said. And then you're asked to take a look at the reasonableness of her testimony in light of the other evidence. In order for her to prevail in this case, in order for you to believe her, because it actually comes down to whether or not you believe her. If you believe her, then certainly you can apply the jury instructions. But it comes down to whether or not you believe her. The other evidence, all of the other evidence that's out there, contradicts her. So you have to go against all of the evidence that's out there, turn your back on all of that, and say, I believe her, therefore I'm going to find in her favor. The state submits to you that, in light of everything, that's not something that you should do. So what standard do you apply? Well, the standard that you apply is the burden of proof instruction, which tells you proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Firmly convinced is the term. It's not any of the other terms that you may have heard anywhere else in life. It's just firmly convinced. And it does tell you there are very few things in this world that we know with absolute certainty. So absolute certainty is not required. And it does say that criminal law, that the law does not require proof that overcomes every doubt. That's not what we're talking about here. You just need to be firmly convinced. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. That's how it reads, and that's the procedure that you indicated that you would follow should you be chosen to go back there to resolve this case. Once you make that inquiry, and once you find the defendant guilty, that's the end of the inquiry. The other language that falls after that involves you finding reasonable doubt. But if you find, based on your consideration of the evidence, that you are firmly convinced, that's the end of the inquiry. You don't need to go any further. And there is only one charge in this case. And the charge is first-degree murder. And first-degree murder can be committed in one of two ways. Obviously, you know this, that there is not two charges of first-degree murder. There is only one. But there are different ways in which these can be committed. First is premeditated murder, or second is felony murder. With regard to premeditated murder, there are lesser included offenses, as the jury instructions have told you. There are other offenses, not necessarily lesser, but other offenses that are involved. With regard to felony murder, there are no lesser included offenses. So, for example, if you are considering felony murder, there are no other offenses that are to be considered. The only issue with regard to felony murder is whether or not, in the course of a felony, she killed him. That's basically what the law says. And if you find that, that's the end of the inquiry. You don't consider lesser included offenses. Premeditated murder does have these lesser offenses. But in terms of the tabulation that takes place at the end, for example, 9 of you could find that this was premeditated murder, 3 of you could find that this was felony murder, and it's still first-degree murder. You do not have to be unanimous as to the theory involving the murder. Or you could be 6 and 6, or it could be 12 for premeditated murder and 12 for felony murder. It's still only one charge. You do not have to be unanimous as to the theory of the crime. And let's talk about premeditated murder. Well, it requires that it be proven that the defendant caused the death of another person. Well, exhibit number 207, he's dead. That element is proven. Well, the defendant intended or knew that she would cause the death of another person. That's also proven. One of the things that we know in this particular case is that, amongst other things, she slit his throat, she stabbed him in the heart, and we also know that she shot him. There are 3 different ways that she killed him. So, did she intend? Sure. Did she know? Absolutely knew. Remember, I was talking about how directed it was to the throat. If you do that, then you know, anybody knows, that if you do that to the neck, you're going to kill somebody. So she both intended it or knew. In other words, it could be either or. In this case, she knew. And also intended it based on what we see in this particular case. So those elements are satisfied in this case. There is no doubt about that those 2 elements are satisfied. Now the issue is whether or not she acted with premeditation. And premeditation means that a defendant intended to kill another human being, and then there's the disjunctive or knew. It doesn't say the defendant intended to kill another human being, and then it stops. It says intended to kill another human being or knew she would kill another human being. That is the element that's above in number 2. She knew that she was going to kill him. There's 3 different ways that she killed him. One of those 3 satisfies this, knew she would cause the death of another person. And after forming that knowledge, after knowing that she was going to kill him, because it talks about intending or knowledge, after knowing that she was going to kill him, because it talks about intending or knowledge, after knowing, after forming that intent or knowledge, reflected on the decision before killing. And the key here is, what is reflection? What does that mean? And it defines it for you. It tells you that it is this reflection regardless of the length of time in which it occurs that distinguishes first-degree murder from second-degree murder. What that is telling you is that you don't even have to have a day between the thinking and the knowing. You just have to have a length of time regardless of the length. So it can be very short. It can be as short as stabbing him in the shower, and then after a couple of minutes, it can be very short. It can be as short as stabbing him in the shower, and then after a couple of minutes, chasing him down and going for the throat. No one can dispute that he walked that way to get away from her. No one can dispute that he was already injured. He was already going to die. When this was applied, by this I mean the strike to the throat, she knew he was already going to die, but that type of injury indicates you want that person to die. Additionally, when she shot him in the head, although reflection is not necessarily prolonged. Again, it's telling you it doesn't have to be days, it doesn't have to be hours, it doesn't even have to be minutes. And then it tells you in the space and time between the intent or knowledge to kill and the act of killing may be very short. In this case, I guess it depends on who you ask. Knowledge to kill. and the act of killing may be very short. In this case, I guess it depends on who you ask, this was a long period of time for Mr. Alexander to be going through this. Just a long period of time between the stab wounds to the heart in the shower when he was defenseless to the time that he was trying to get away and going along the wall and absolutely falling down. So in this case, it can be very short. She killed him 3 different ways. She knew that she was going to kill him. Additionally, not only that, she brought the implements. She brought the gun. If she didn't bring the gun and it was Mr. Alexander's, did she have his permission to take that gun? According to her, it was his gun. If she took his gun, then that's a burglary. And if during the burglary somebody dies, i.e. stealing the gun, if she took his gun, then that's a burglary. And if during the burglary somebody dies, i.e. stealing the gun, then that's premeditated murder. Either way you look at it. But we'll talk about that in a little bit more. And an act is not done with premeditation if it is the instant effect or a sudden quarrel or heat of passion. How do you know if it was or wasn't the instant effect of a sudden quarrel or heat of passion? Well, you can take a look at some of the photographs that we have, and they will tell you that it wasn't the instant effect of a sudden quarrel or heat of passion. 160 tells you, does that guy look like he's ready to fight? Somebody who is telling us that. A liar who was dressed at the time. A liar who was poised to strike. If she didn't have a plan, why does she have her clothes on? Why does she need to have her clothes on? And why is it that the gun is with her? She says, oh no, the gun belonged to Mr. Alexander. But if you remember on June 10th of 2008, she called unsolicited to this police officer and said to him, oh no, Travis never had a gun. Travis never had a gun. The only thing that he had were his fists. So, yeah, and you have that on tape. There is no doubt that she said it. In fact, there is a tape that says, Jodi Arias' number is whatever it was, and you heard her voice. And you also heard her saying, he did not have a gun. At that time of the investigation, she didn't know how important it was going to be. She didn't know what lies she was going to be telling in the future. She said he did not have a gun. So if he didn't have a gun, she brought it. And you know that she did bring it. You know about the supposed burglary of her grandparents' house. And so she says that in order for you to believe that this was a sudden quarrel or heat of passion, you have to say to yourself, well, you know, she called the police on her own and she lied to him, but since she's been such a liar and she lied to us in this courtroom, I'm now going to decide to believe her when she makes up a story and says, oh, his father gave it to her. And in addition to that, I'm going to have to believe that the shooting did not occur in the closet as she told Alice Laviolette, because that's what she told Alice Laviolette, the person who took this stand. Isn't that what she told Alice Laviolette? Do you remember what Alice Laviolette testified? That that's what she told her. And in fact, there was a recording of the conversation between the prosecutor and her at an interview that took place in November of last year, in which you heard her say, oh yeah, she told me that the shooting happened in the closet. You're going to have to disregard all of that so that you can even get to the sudden quarrel or heat of passion. That's the problem for the defendant. Are you going to be willing to do that? Especially when the police have looked in that place and there wasn't anything indicating that there were any bullets there. There's nothing to indicate that he had any cleaning supplies. Nothing to indicate that there was a gun. The other thing that is problematic, that it would allow you to reach that, is the shelves. You would have to, you know the shelves, you've seen what the shelves look like, those shelves that were in the corner, and by her own admission, she stepped on the second shelf as she was going to get the gun. You saw what happens to those shelves when you put a little bit of pressure. They move down this way. And you saw the photographs. There was nothing that was the shoes that were there. There was nothing that looked that like there had been any activity there. Everything, the photographs, the forensic evidence, her statement says that there was no sudden quarrel or heat of passion because she brought the gun. You would have to, again, throw aside everything else she has said to find that there was an instant effect, a sudden quarrel or heat of passion in this case. What do you want to do as you sit back and deliberate? What do you want to do with one of the first conversations that she ever has with the police before she knows what the issues are and says, "He didn't have a gun"? What possible reason or justification can she give you to say, at that time, I lied to him? Why? Well, she said before, well, I was afraid initially. She said when she spoke to the officer back on July 15th. That's why I made that first story. Then the second story, well, I was trying to not get in trouble. But those weren't present. Those reasons were not present on June 10th of 2008 when she called this detective unsolicited to talk. It's because she wanted to learn about what the police knew so that she could incorporate it in her story should something come up. But with the truth, you ain't got to remember nothing. And she forgot about some things and made that statement involving the gun. And that's problematic for her. It will stay as part of this record, and it will require you to sit back there and listen to that and say, you know what? She was lying there instead of telling the truth there. And that would require you to disregard the fact that a .25 caliber handgun was taken during a supposed burglary of her grandparents' house, and that was the gun that was used to kill her. The issue of the gun will not go away, especially since she said that he didn't have one, especially since she also indicated that there was a circuitous route through the closet, especially when she could have just walked out. The guy's naked. He's not going to run after her outside naked. And then indicating that she came through the closet, shoots him in the closet, according to some accounts, shoots him outside of the closet in the bathroom, and grabs a gun that she believes is unloaded. If she believes the gun is unloaded, what is she going to do with it? Throw it at him? Why stand there with the gun if you know it's unloaded? None of it. Absolutely none of it is true. You could even be charitable and say it doesn't make sense. I'm not asking you to be charitable. It's an absolute lie of this issue about the gun. She said it, and she is wedded to it. I won't even discuss the lesser included offenses because of the issue involving the gun. She brought it herself. Felony murder requires the state to prove two things. The first one is that the defendant committed or attempted to commit a burglary in the second degree. What is a burglary in the second degree? And notice it says attempted or committed the burglary. The crime of burglary in the second degree requires the defendant, in this case, to enter or remain unlawfully in or on a residential structure. We don't know if she was invited in. We really don't know if she was invited in at all. So, but did she remain unlawfully? I think it's not a stretch to say that an individual who owns a home and is being stabbed to death, that the person that's doing the stabbing there no longer is entitled to remain lawfully in that house. No, I may be charitable, I may be a nice guy, but you know what? If you start stabbing me, you're no longer here lawfully. That consent to come in is no longer there. If you keep stabbing me, that's it. It is not a stretch of the imagination to say that. And we understand, the state understands that Mr. Alexander is not here to say, I revoked my consent. But if he's being stabbed, if he's having his throat slashed, and if he's being shot, It is not a stretch to say, based on circumstantial evidence, to say that she remained unlawfully. So she has remained there unlawfully. Is it a residential structure? It absolutely is. So that's his house. And she did so with the intent to commit any theft. Well, at some point she stole the gun, according to her, or a felony therein. You can bet that stabbing somebody is a felony. So he doesn't want you to be there, and you're stabbing him, and you're killing him. That's a felony. So the elements of burglary have been satisfied. So we go back to the first prong, and it says the defendant committed or attempted to commit burglary in the second degree. Yes, he did accomplish the burglary. So that element is satisfied. Number two, in the course and furtherance of committing this burglary that we know that she committed, or immediate flight from it, in other words, she took off and she took his gun. So that's the theft right there. And as part of that, even if it wasn't her fault, the defendant caused the death of another person. If you are committing...
Objection, this states the law.
Overruled.
The defendant caused the death of another person. And she did cause the death of Mr. Alexander during this burglary. She took off, and she took off with his gun after stabbing him. So she has committed murder in the first degree under both theories. It isn't just one theory that she has committed this crime under. And so now you're left with the decision that you have to make. The one admonition that I leave you with is that these jury instructions are not advisory. They are mandatory. And it's a situation where you go back there and you read them. And as you sit back and you decide this case and you attempt to reconcile the lies with what actually happened, keep in mind that the defendant has attempted to manipulate you, has attempted to paint the picture for you. For example, something like this. This is what she wants you to believe. Something like that. There's Mr. Alexander and her. That's what she wants you to think. That's what the feeling that she wants you to have. But actually, reality is this. That's really what we're talking about in this case. That's his back, not his throat. But you've seen his throat already. And that's really the reality in this case. And as you consider this case, and as you ponder your decision, one of the things that I want you to consider that is symbolic of this whole case is that this issue involving the gas cans. What she wants you to do, because you know it's a lie, what she wants you to do is disregard it. But symbolically speaking, when she asks you to disregard it, what she wants you to do is she wants you to carry those gas cans for her. She wants you to help her fill them with gas. That's what she wants you to do, symbolically speaking. What the state is asking you to do is to not leave this courtroom filled with the stench of gasoline on your hands. That's what we are asking you to do, because it's not true. But she's already talked to you about these gas cans. It's not true that she returned them, but she's asking you to help her. She's asking you symbolically, help her by carrying them out and taking those cans with you. What the state is asking you to do is your duty. And the judge has indicated that your duty is to follow the law as she's given it to you and apply it to the facts. And in asking that, the state is asking you that you return a verdict of guilty, and that you return a verdict of guilty as to first-degree murder. not only as premeditated murder, but also as to felony murder, for no other reason that it's your duty and the facts and the law support it. Thank you.
All right, ladies and gentlemen, we were here late last evening, so we are going to adjourn for the evening now. Please be back tomorrow morning. We will start promptly at 9 o'clock. Please remember the admonition. Are there any questions? You are excused. Have a nice evening.